Welcome back. Today I was reviewing a script that reminded me how the quietest forms of destruction are always the most complete. This one does not rely on confrontation or tears. It relies on a single legal flaw, buried in a document the husband was certain had already won. The brilliance is that he handed her the weapon himself. You're watching Historical Manhwa. The first thing Vivian noticed when she walked into the law office of Kwan Adler and Park was the smell of cold coffee. Not the elegant, slow-roasted kind that Marcus kept in a titanium thermos on his desk. This was the gas station variety, sitting too long in a paper cup on the reception desk, its surface gone slightly iridescent at the rim. She stood there for a moment, inhaling it, and felt something in her chest unknot just slightly. She had spent 6 years in rooms that smelled like wealth, cedar and leather, and the faint mineral sharpness of expensive cologne. And none of those rooms had ever told her the truth about anything. She adjusted the strap of her bag, canvas, not the Hermes she'd left behind in the penthouse closet, and walked to the front desk. The receptionist, a young man with ink on his left thumb, looked up. "Oh, Vivian Chen, I have a 9 o'clock. He typed something, nodded. "Mr. Kwan is ready. Third door on the left." The hallway was narrow, and the overhead light on the left side had a flicker to it, the kind that suggested the building's electrical wiring was somewhere between functional and a fire hazard. The carpet was the color of a dried creek bed. There were framed law degrees on the wall, crooked by about 2 degrees each, as if the person who'd hung them had measured everything correctly and then nudged each one slightly off at the last second just to see if anyone would notice. Vivian noticed. She always noticed things like that. Daniel Kwan was shorter than she had imagined from his voice on the phone. He was 42, maybe 44, knit with close-cropped hair, and the kind of face that seemed to have been designed specifically for a courtroom. Sharp cheekbones, a mouth that rested in a naturally neutral line, eyes that processed everything with a patience that was almost unnerving. He wore a gray suit that had been pressed to perfection, which felt incongruent with the general state of the office around him, until she realized that the office was a deliberate choice. A tax consideration, perhaps, or simply a man who spent all his precision on his work and none of it on aesthetics. "Ms. Chen," he said, not standing, just extending a hand across the desk. "Sit down." She sat. She placed the canvas bag on her lap. Inside it was a manila folder. And inside that folder was the document Marcus had presented to her on the evening of their 4th wedding anniversary. A night that had begun with a private dinner at a restaurant where a single tasting menu cost more than her first month's rent, and ended with her signature on 11 pages of dense legal language that had taken her, at the time, approximately 20 minutes to skim. She had been 31. She had trusted him. She had believed that the word postnuptial was simply a formality, the kind of administrative tidiness that wealthy families use to organize their estates. Marcus had told her that. His father, Richard Harlow, had told her that. Even Marcus's personal attorney, a silver-haired man named Jeffrey Baines, who drove a car that cost the same as a small apartment in Queens, had told her that. Safi, what none of them had mentioned was that Jeffrey Baines had been representing Marcus since 1998. That Baines had drafted the postnuptial agreement. That in the state of New York, for a post-nuptial agreement to be enforceable, both parties were required to have independent legal counsel review the document before signing. She had not had independent legal counsel. She'd had a glass of champagne, and a man she loved telling her it was just paperwork. Vivian set the folder on Kwan's desk. He opened it without ceremony, the way a surgeon opens a chest cavity, with the specific kind of calm that comes not from indifference, but from absolute command. He read the first page, then the second. He did not say anything for several minutes, and she did not fill the silence, because she had spent 6 years learning that the people who fill silence are usually the ones who need something from it. On the 7th page, Kwan paused. He reached into his desk drawer, retrieved a yellow legal pad, and wrote something down. 3 words, though she couldn't read them from across the desk. "Who was your attorney when you signed this?" he asked. "I didn't have one." Kwan looked up. "Baines told me the agreement was standard, that it only concerned the Harlow family properties that predated our marriage, that it had no bearing on anything we'd built together." "And you believed him?" "I was 31, and I had been married for 4 years, and I thought the man I married was a person of integrity, yes." She kept her voice level. She had practiced keeping her voice level. I also believed it because he made it very clear that if I refused to sign, the discussion about my mother's care facility would be reopened. Kwan's pen stopped moving. He was funding her care, Vivian said. Parkinson's, a private facility in Connecticut, $8,000 a month. He told me, not directly, because Marcus never did anything directly. He told me that the family accountant had flagged the expenditure as a personal gift rather than a family obligation, and that it would need to be reevaluated at the next quarter's financial review. She paused. The financial review was 3 weeks after the anniversary dinner. There was a long silence. I'm going to need you to write all of that down, Kwan said. Exactly as you told me, in your own words. Yeah, with dates if you have them. I have dates. She reached into the canvas bag and produced a second folder, thinner than the first. I kept a personal journal. My therapist suggested it after my first year of marriage. I've been doing it since. Kwan looked at the second folder. Something in his expression shifted. Not dramatically, barely perceptibly, the way a chess player's posture changes when they see 3 moves ahead. Ms. Chen, he said, when did you first suspect there was a problem with this agreement? She thought about that. The honest answer was that she had suspected something was wrong on the night she signed it, because she had noticed the way Richard Harlow watched her hand move across the signature line, not with the polite neutrality of a father-in-law observing a family matter, but with the barely contained satisfaction of a man watching a trap close. She had filed that observation away in the same place she filed all the small wrongnesses of her marriage, a drawer she kept shut because the alternative was acknowledging what lived inside it. The practical answer was different. 8 weeks ago, she said, my former colleague Diane Park was going through her own divorce. She sent me an article about post-nuptial agreements in New York. Enforceability standards, the independent counsel requirement. She paused. I read it 3 times. And then you called me. And then I spent 2 weeks researching your case record, and then I called you. Kwan set down his pen. He leaned back in his chair, which creaked in the specific key of old office furniture. And he looked at her with the kind of steadiness that she had not received from any person connected to her marriage in a very long time. Tell me about the assets, he said. This was the part she'd been preparing for, not emotionally. She was past emotion on this, or at least she had placed it somewhere she could reach later, when it was useful, and for now she was operating in the clean register of facts. She'd been preparing practically. 2 weeks of preparation, the same focused attention she'd once given to quarterly compliance reports at Meridian Financial Group back before Marcus had suggested, charmingly and with great apparent reasonableness, that a woman of her intelligence shouldn't waste herself on corporate audits when she could be managing their social calendar and supporting his expansion into Southeast Asian markets. She had been, prior to her marriage, a senior compliance officer. She understood financial documentation. She understood disclosure requirements. And over the past 2 weeks, she had understood something else. During our marriage, she said, Marcus's declared net worth increased from approximately $42 million to what his most recent financial statement to our bank lists as $118 million. I was present for most of that period. I attended board meetings. I read the annual reports of his holding companies. I signed tax returns as a co-filer. She looked at Kwan steadily. The numbers I signed off on never reflected the actual growth I observed in his operations. Kwan was very still. I also noted, she continued, that in 2019, Marcus restructured 3 of his primary real estate holding entities. He moved them from personal LLCs to a family trust structure managed by Harlow Legacy Group, LLC, which is registered in Delaware. The restructuring occurred approximately 6 months before he presented the post-nuptial agreement. She reached into the canvas bag for the 3rd time and placed a 3rd folder on the desk. These are the Delaware incorporation records, the trust documents I found in his home office, and a timeline I constructed showing the sequence of events. Kwan did not move for a moment. Then he picked up his pen again and began writing at a pace that suggested the legal pad might not be sufficient. Outside the window of his office, Midtown was doing its morning thing. The compressed chaos of taxis and pedestrians and a delivery truck blocking 2 lanes of traffic while its driver consulted a phone with the serene confidence of a man who believed the universe owed him a parking space. The light was the flat, gray-white of a New York morning in early March, the kind that gave everything a slightly washed-out quality, as if the city were still deciding whether it wanted to commit to the day. Vivian watched a pigeon navigate a windowsill 3 buildings down. She waited. "The Postnup," Quan said finally, "is a problem for Marcus, not for you. No independent counsel. Potential duress, the medical care element is significant. Incomplete financial disclosure, which I'll need to verify, but based on what you've described..." He made a sound that was not quite a laugh, more like a controlled exhale through the nose. "The agreement is, in my preliminary assessment, almost certainly unenforceable." She had known this was coming. She had constructed the argument herself, tested it against every counter-argument she could manufacture, and arrived at this conclusion 2.5 weeks ago. Hearing it from someone else still did something to the air in the room. "Almost certainly," she said. "I'll need to review the full document, run the financial records, speak to a forensic accountant I work with named Clara Voss. She's the best in the city for this kind of asset tracing. But yes, almost certainly." He looked at her. "Now, the more important question. Why did he want you to sign it?" Vivian thought about a woman named Sophia Brennan. She was 27 years old. She had copper-colored hair and the kind of easy confidence that came from never having been made to feel invisible. She worked in Marcus's media division in a role that had been created approximately 11 months ago, and that required her to attend most of the same events Vivian used to attend at Marcus's side. Vivian had seen her 3 times before she understood what she was seeing. The 3rd time, she'd watched Marcus rest his hand on the small of Sophia's back at a charity gala. A specific placement, a specific pressure, the kind of touch that contained a whole private language. And she had excused herself to the bathroom, stood at the sink, and stared at her own reflection for 60 seconds with the strange, suspended sensation of watching the world reorganize itself around a fact she had been refusing to see. "And he has someone," she said. "And he's been planning this for longer than I realized." Quan nodded, as if this explained everything. Because it did. The next 3 weeks were not dramatic. That was one of the things Vivian had decided going in. That she would not be a woman who made drama. Because drama was expensive and imprecise, and it warned your opponent. She had watched enough women in her life go through the kind of divorce that involved screaming matches and thrown objects and lawyers exchanging furious emails at midnight. And she had observed with her compliance officer's precision that those women rarely won. They were too visible. Their grief was a signal fire that told the other side exactly where to aim. She stayed in the penthouse. She attended Marcus's business dinners. She smiled at Sophia Brennan at 2 separate events and complimented her dress on one occasion, which was a shade of burnt orange that did suit her, and which Vivian mentioned with perfect sincerity, because the compliment served as excellent camouflage. And she had learned from 6 years of marriage to a strategist that the most effective moves were the ones that looked like nothing at all. Marcus, meanwhile, behaved like a man who had already won. This was, she had come to understand, his primary vulnerability. He was brilliant in the way that men who have always had resources and always had other people managing the details are brilliant. He could see the broad shape of a game, the architecture of a deal, the narrative of a victory. What he could not do was see the small things, the flickering light, the ink on a thumb. Out the compliance officer's mind that had spent 6 years filing observations in a drawer and was now opening that drawer and spreading its contents across a legal pad in an office that smelled like cold coffee. Clara Voss arrived at Quan's office on a Tuesday morning, 3 weeks after Vivian's initial consultation, and she was the kind of woman who made Vivian feel, for the first time in years, that she had chosen the right side of this particular fight. She was 51, with silver-streaked hair that she wore in a practical bun, and she set a laptop and 3 accordion folders on the conference room table with the brisk efficiency of a woman who charged $450 an hour and intended to earn every dollar of it. "I've been through the financial records you provided," Clara said, opening the laptop. "The compliance filings from Harlow Holdings' annual reports, the tax returns you co-signed, the Delaware trust documents. I've also run some preliminary searches on the subsidiary structure of Harlow Legacy Group." She turned the laptop to face them both. "Do you want the simple version or the technical version?" "The technical version," Vivian said. Clara looked at her with something that might have been approval. "The technical version is this," she said. "Beginning in 2018, 2 years before the postnuptial was presented, Marcus began a systematic restructuring of his marital assets. He transferred the primary income-generating properties, the Tribeca commercial development, the Midtown Hotel portfolio, and the Long Island Sound waterfront parcels, out of the marital LLC structures and into the Harlow Legacy Group Trust. So now that trust is administered by Richard Harlow as trustee. On paper, these are now family legacy assets that predated the marriage." She paused. "They did not predate the marriage. The Tribeca development was acquired in year 2 of the marriage. The hotel portfolio was acquired in year 3. The waterfront parcels were acquired in year 4, 3 months before the postnuptial was presented." Vivian heard something in her own breath change. She kept her face still. "The declared value of those assets on the postnuptial agreement," Clara continued, "is $47 million. The current market value, based on independent appraisal comparables I've pulled for this neighborhood and current commercial real estate indices, is approximately $190 million. She waited for that to settle. Now he disclosed $47 million on the agreement. The actual value was, at minimum, 4 times that. Quan had his legal pad open. He was writing without looking at it. A habit that Vivian had come to recognize as a sign of heightened focus. When his attention was entirely on what was being said, his hand moved automatically. "Fraudulent concealment of material assets," Quan said, not as a question. "Comprehensive and deliberate," Clara confirmed. "This isn't an oversight in the disclosure schedule. This is a sequential, legally structured concealment that required a tax attorney, a trust administrator, and a Delaware incorporation agent. It has been, professionally speaking, a rather sophisticated operation." "How sophisticated?" Vivian asked. Clara looked at her. Sophisticated enough that someone who wasn't a forensic accountant, and who wasn't looking specifically for this, probably wouldn't catch it. The Delaware structures are designed to be opaque. The trust documents use standard language. The asset values are technically defensible in isolation." She paused. "But the sequence, the timing, is extremely damaging. When you map the transfers against the dates, you can see that almost every significant asset movement happened within a 24-month window leading up to the postnuptial agreement. It reads, to someone who knows how to read it, like a prepared position." Vivian thought about Richard Harlow watching her sign the document, the specific quality of his satisfaction. She thought about how she had once believed, genuinely believed, that Marcus's father liked her. Mouthed that the Christmases in the Harlow family home in Greenwich, the kind of house that had a name, Aldercroft, which was etched into a brass plate by the gate, had represented a genuine inclusion. That when Richard took her aside at the first of those Christmases and told her he was glad Marcus had found someone with her particular kind of intelligence, he had meant it as a compliment rather than as a preemptive assessment of a threat level. She had been 40 miles below the threat level they imagined. She had been 31 and in love and filing observations in a drawer. She was 37 now, and the drawer was open. "There's one more thing," Clara said. She opened one of the accordion folders and laid 3 pages of financial records on the table. "This is a summary of transactions I traced through the trust's operating account over the past 18 months. There are regular outflows, structured as advisory fees, to a consulting LLC registered in the name of Sophia Marie Brennan." She placed her finger on a line of figures. Total amount, $814,000. The room was very quiet. Vivian looked at the number. She had the strange, distant sensation of watching herself from slightly outside her own body, the kind of dissociation that occurs in moments when the evidence surpasses even the most coldly constructed expectations. She had expected to find Sophia. She had expected there to be money moving in her direction. She had not expected $814,000 disguised as consulting fees. Which meant that Marcus had not merely been conducting an affair, he had been funding a parallel life from marital assets, which meant dissipation of marital estate, which meant, in the language of New York divorce law, that she was entitled to credit for those funds. She picked up the page. She read the summary twice. She set it back down. "How long have you known this?" she asked Clara. "I confirmed it 48 hours ago. I wanted to be certain before I presented it." Vivian nodded. She reached for the canvas bag, which she had set on the chair beside her, and she unzipped the front pocket and removed a small notebook. Not the journal, a different one, with graph paper inside, and a system of notation she had developed over a decade of compliance work. "What's the aggregate claim value?" she said. "If we proceed on the basis of invalid Postnup, fraudulent concealment, and marital asset dissipation?" Quan looked at Clara. Clara looked at her laptop. "Conservatively," Clara said, "and accounting only for what I can currently document, we're looking at a position where your equitable share of the marital estate, with the post-nuptial agreement removed from the equation, is in the range of $70 to $90 million. If the court awards punitive adjustments for the concealment and the dissipation, that number increases." She paused. Significantly, Vivian wrote the figure in her notebook. She capped the pen. She looked at Quan. "How do we proceed?" Quan set down his legal pad. He looked at her with the sustained assessing attention she had come to associate with moments of genuine gravity. "We file," he said. "Oh, standard petition. Nothing in the filing signals what we actually have. We want him to answer the petition with the post-nuptial agreement as his primary defense, because the moment he formally relies on that agreement in court, he has introduced the document into the proceedings and opened the door for us to challenge its validity." He leaned forward. "Once we challenge validity and the court orders full financial disclosure, which they will, because that's standard in contested equitable distribution, Clara's findings go before a judge, and Marcus Harlow has to explain, under oath, why he disclosed $47 million in assets on a document when the actual value was $190. Vivian considered this. "He'll know when we file," she said. "Yes. He'll try to move assets. He'll try. But the assets inside the trust are in a structure he built specifically to appear immovable, because they're supposed to look like legacy holdings that couldn't have been touched anyway. He can't dissolve the trust quickly without triggering tax events and creating a paper trail that would be even more damaging than what we already have." Quan paused. "He built a cage to put your assets in. The cage is now his problem." She filed the image in the drawer, not the open drawer, a different one. "When?" she said. "I'd like 2 more weeks to finish the financial documentation. Then we file." She stood. She picked up the canvas bag. 2 weeks, she said. She left the conference room. She walked back down the hallway with the flickering light, past the crooked law degrees, past the reception desk with the cold coffee. She pushed through the glass door into the flat March light of Midtown and stood on the sidewalk for a moment in the stream of people moving around her, and she thought about nothing at all for approximately 10 seconds, which was longer than she had managed in several weeks. Then she put on her sunglasses and went to buy a decent cup of coffee, because she was still going to be at the penthouse dinner table by 7, and she needed to be present for it. The dinner that night was with 2 of Marcus's investors, Japanese nationals associated with a media conglomerate that Marcus had been courting for a partnership in his digital properties. They were courteous men in their 50s, Takahashi-san and Moriya-san, and they spoke excellent English and drank the wine Marcus poured with the appreciation of people who understood quality without requiring performance. Marcus was at his most polished version of himself, which she had to admit, even now, was a remarkable thing to witness. He had a gift for making each person at a table feel like the most important person in the room, a quality she had once found deeply attractive and now recognized as a tool. She sat at the other end of the table and played her part. She asked Moriya-san about his daughter's graduate program at Columbia, which she remembered because she remembered everything, and Moriya-san's face lit up in a way that was genuinely warm and gratified, and she saw Marcus notice this from across the table with the quick, approving flicker of a man who still believed her value to him was entirely social. She ate the lamb. She drank 1 glass of the wine. She refilled Takahashi-san's water glass without being asked, because she had been doing this for 6 years, and the muscle memory was a form of camouflage she no longer had to think about. After the guests left, Marcus poured himself a 2nd glass of the scotch he'd kept back during dinner and stood by the floor-to-ceiling windows with the expression he wore when he was satisfied with himself, which was a specific quality of ease, the loosening of the shoulders, the slight elevation of the chin. "Good evening," he said, not to her specifically, just into the room. "Yes," she said. She collected her phone from the console table. Takahashi wants to move forward. I could tell from the way he asked about the media licensing terms. When men start asking about specifics, they've already decided. That's good, she said. You were useful tonight. The Columbia thing, how do you keep track of all that? She looked at him. I pay attention, she said. He looked at her with the fraction of condescension that he probably didn't know was visible, the slight flattening of the gaze that said, you are a useful person, and I have arranged for you to remain useful in appropriate ways. She said goodnight and went to the bedroom. She lay in the dark for a while, not sleeping, and she thought about the first night she had spent in this penthouse, how the city below had looked like something she had only previously seen in films, how she had stood at these same windows at 2 a.m. and thought, aught with the overwhelming sincerity of someone who had grown up in a 2-bedroom apartment in Flushing, with a mother who coupon-clipped and a father who worked double shifts and called it a life, that she had arrived somewhere. She had not been naive. She had been 31 and accomplished, and she had earned her place in that room through legitimate work. But she had also been in love, which is the specific kind of clarity impairment that no amount of intelligence protects you from. And she had believed that the architecture of the life around her was real, because the feeling inside her had been real, and she had not yet understood that those two things have no necessary relationship. She understood now. She turned on her side and closed her eyes and slept for 6 hours, which was sufficient. On as the 2 weeks passed in the manner of days that are outwardly unremarkable and inwardly immense. She attended a charity luncheon. She had dinner with a friend named Nina, who did not know anything about the divorce, and was still talking about Marcus the way people talk about someone's husband when they have only seen the curated version. And Vivian listened and said in the appropriate places and thought about Clara Voss's accordion folders. She visited her mother at the care facility in Connecticut on a Thursday, sat with her for 2 hours in the sunroom while her mother moved her hands in the small, careful gestures that Parkinson's had made the primary language of her body, and she held those hands and talked about ordinary things. The weather, a book she had been reading, a pigeon she had seen navigating a windowsill, and she thought, with a cold clarity that was not without feeling, but that she had decided to place on the other side of the action, that no one was going to leverage her mother's care again. She had transferred 6 months of care facility payments to a separate escrow account 3 days after her first meeting with Kwan. A quiet arrangement with the facility director. A simple instruction from a compliance officer who had spent a decade making sure things were documented correctly. On a Wednesday morning in the 3rd week of March, Kwan filed the divorce petition in New York Supreme Court, New York County. She was at the penthouse when Marcus's phone rang. She heard it from the kitchen, where she was making tea. And she heard the specific quality of silence that followed when he answered, and then the controlled modulation of his voice dropping to a register she recognized as crisis management. She poured the tea. She carried it to the small table by the window, where she sometimes sat in the mornings, and she looked at the city, and she drank it. He appeared in the kitchen doorway 43 seconds later. He was wearing a white shirt, open at the collar, and he had already reconstructed his face into something that was meant to read as calm, but was operating on the infrastructure of controlled alarm. I just got a call from Jeffrey, he said. She looked at him. You filed for divorce? Yes. A pause. Vivian, my lawyer will be in contact with Jeffrey's office today. She set the cup down. Oh, I'd prefer not to discuss the specifics here. Something moved across his face that she might once have been willing to call pain. She looked at it the way she looked at a variance on a financial report, with attention but without sentiment. The post-nuptial agreement. He began. I'm sure Jeffrey has thoughts about it, she said. She picked up the cup, walked to the sink, rinsed it, set it in the rack. She picked up her bag and her coat from the hook by the door. I'll be at Nina's for the next few days, she said. My attorney will send over the temporary arrangement proposal by end of business today. She left. The elevator doors closed behind her. She rode down 29 floors in the polished quiet of a building that cost an amount of money she had once considered permanent and now understood to be negotiable. And she stepped out into the lobby and through the glass doors onto the street, where a taxi was already pulling to the curb in the ambient telepathy of New York. And she got in. She did not look back at the building. She did not need to. Jeffrey Baines responded to the petition, as Kwan had predicted, with the post-nuptial agreement as his primary defense. The response arrived within 4 days. faster than standard, which told Kwon everything he needed to know about how alarmed they were, the speed of the response being inversely proportional to their actual position, and proportional only to the performance of confidence. The response argued that the post-nuptial agreement was a valid, binding instrument executed in good faith by both parties, that it clearly delineated the disposition of marital and premarital assets, and that the petitioner was therefore entitled to the provisions specified therein, which, as Vivian had known since the second time she read the document with the eyes of a compliance officer rather than the eyes of a woman who had been in love, amounted to $2 million. The use of a car, and the contents of a personal bank account that Marcus had been ensuring remained below $300,000. Kwon read the response. He read it twice. He wrote 3 words on his legal pad and turned it to face Vivian across the desk. It said, "They took the bait." The challenge to the post-nuptial agreement's validity was filed 3 days later. Kwon had prepared it with the thoroughness of a man who understood that the first document in a contested proceeding sets the tone of the entire engagement. It was 47 pages long. Anand addressed, in precise and extensively documented sequence, the absence of independent legal counsel for the petitioner, the presence of economic duress in the form of a threatened disruption to dependent medical care, the inadequacy of the financial disclosure schedule attached to the agreement, and the fraudulent misrepresentation of asset values, supported by Clara Voss's forensic analysis. Attached to the challenge as Exhibit C was Clara's preliminary report, 42 pages of financial reconstruction, transaction timelines, Delaware trust structures, asset transfer sequences, and the consulting fee payments to Sophia Brennan's LLC. The attachment about the consulting fees was not strictly necessary to the validity challenge. But Kwon included it because it was relevant to the marital asset dissipation claim they would be filing separately. And also, she suspected, because Daniel Kwon had been in this profession for 18 years and understood that certain information, once placed before a judge, sets a particular tone that persists through every subsequent proceeding. Jeffrey Baines called Kwon within 3 hours of the filing. Kwon relayed the conversation to Vivian that afternoon. She was sitting in the small conference room with a cup of coffee, the good kind, from the place across the street, which she had discovered on her second visit and which had become a small, reliable pleasure. And she listened. "He wants to discuss settlement," Kwon said. "They're proposing to increase the post-nuptial provision to $8 million. She drank the coffee. "Oh, no." That was my response also. A slight pause that contained something that might, in a different person, have been amusement. He then suggested $15 million as a final and comprehensive resolution. What did you say? I told him I'd need to consult with my client, and that in the meantime, I would be proceeding with the motion for full financial disclosure ordered by the court, and that we would be filing the separate dissipation claim by end of the week. He paused. He was quiet for a moment, and then he said, "Daniel, we've known each other a long time." And I said, "Jeffrey, you didn't call me Daniel when you bailed me out of this deal 14 years ago?" And then we were both quiet. Vivian set down the coffee cup. "What's your read?" she said. "They're scared," Kwon said. "The forensic report scared them. Us because they can see that Clara's methodology is bulletproof, and they know that under full disclosure, the picture gets worse, not better. They want to settle before the court orders Marcus to open the books." He looked at her steadily. "The question is what you want." She had thought about this. She had been thinking about it for 2 weeks, on train platforms and in hotel rooms and in the sunroom of her mother's care facility, while she watched her mother's hands move in the careful language of a disease that cost $8,000 a month to manage. "I want the Tribeca commercial development," she said. "I want my equitable share of the marital estate based on accurate asset valuation. I want 6 years of care facility costs for my mother treated as a marital obligation rather than a personal gift. Guido, which means the trust reimburses that amount. I want the consulting fees paid to Sophia Brennan LLC credited as dissipation of marital assets, which affects the distribution calculation." She paused. "And I want the legal fees paid by him as a condition of settlement, given the fraudulent conduct." Kwon wrote it down. "That's a number in the range of 80 to 95 million. He said. "I know." "He won't settle at that number without a fight." "Then we fight," she said. "He has more to lose from a public proceeding than I do." There was a silence. "There's one more thing," Kwan said, "and I want to raise it because you should know about it before we proceed." She looked at him. The structure he built, the Delaware Trust, the asset transfers. Oh, the timing. There's a question of whether this crosses from aggressive civil strategy into territory that interests other people. He held her gaze. "Clara flagged the transaction records to me last week. She believes the undisclosed asset transfers may implicate certain tax filing representations that were made in years when you co-signed the joint returns." The coffee cup was still warm in her hand. She felt the temperature of it with specific clarity. "You co-signed returns that may have contained material misrepresentations," Kwan continued. "That's a liability exposure for you if this becomes a matter of interest to the IRS or the DA's office, which is why—" He opened a folder on his desk. "I've already reached out to a tax attorney colleague of mine, and we've prepared an amended disclosure filing on your behalf. Which documents that you signed the returns in good faith based on financial information provided by your husband, that you had no independent access to the full financial records, and that you are currently engaged in civil proceedings to remedy those misrepresentations." She looked at the folder. "This protects you," Kwan said, "and it also, incidentally, puts Marcus in a position where he cannot claim that the tax filings were jointly executed with full mutual knowledge because your amended disclosure contradicts that claim." He paused. "This is, as a legal strategy, what we might call an encirclement." She thought about the way a compliance officer moves through a set of financial records, not hunting for one specific thing, but building a comprehensive map, and understanding the whole shape of the territory before deciding where to stand. She thought about the brass plate at the gate of Aldercroft, the family house with the name, the Christmas where Richard Harlow had told her he was glad Marcus had found someone with her particular kind of intelligence. She wondered if he had ever imagined it being used like this. "File it," she said. The next 3 weeks were the eye of the storm, which is to say they were full of furious motion that she observed from a still center. Marcus filed a counter-petition claiming that the post-nuptial agreement was valid and raising a number of procedural objections to the financial disclosure order. Baines's office produced, in response to the disclosure order, a set of financial records that Clara described on a phone call that lasted 40 minutes. As incomplete, selectively presented, and in 3 specific instances, internally inconsistent. Clara filed a supplementary expert report with the court identifying the inconsistencies. The judge, a woman named Honorable Margaret O'Say, who had been on the bench for 11 years and had what Kwan described as a zero-tolerance policy for what she considers time-wasting, ordered a supplemental disclosure within 14 days. During this period, Vivian was staying in a hotel in Midtown. It was not a cheap hotel, but it was not the penthouse either, and it had a room service menu that included a passable version of the congee her mother used to make, and she ordered it twice a week and ate it at the small desk by the window while she read through financial documents, or occasionally just looked at the street below. Marcus made 2 attempts to contact her directly. Both times, she let the call go to voicemail. Both times she sent the voicemail recording to Kwan within 10 minutes, because any direct contact was potentially useful, and everything was documentation. The first message was measured. He wanted to speak with her, to find a resolution, to make sure they handled this with dignity. The second message, left 11 days later, had a different quality. The measured tone was still there, but underneath it was something she recognized from the rare occasions in their marriage when things had not gone Marcus's way. A compressed tightness, the tone of a man who is realizing that the game board is not arranged the way he thought it was. She listened to the second message twice, not because it gave her pleasure, but because she was trying to accurately assess his psychological position, which was relevant to predicting how Baines would respond in the upcoming preliminary conference. She assessed, he was not yet panicking. He was recalibrating. He still believed there was a settlement range he could reach that would contain the damage. He had not yet fully processed what the supplementary disclosure requirements would reveal, because he was still operating on the assumption that his filing was sufficient and that Baines could manage the inconsistencies. He was wrong about all of those things, but she had not expected him to see it yet. At the preliminary conference held on a Tuesday morning in a courtroom that smelled of paper and the faint underlying mineral note of old wood, Judge Osi took 20 minutes to review the status of the proceedings, asked Baines 2 questions about the supplemental disclosure that he answered in a way that caused her to press her lips together briefly, and then issued a set of interim orders that included a freeze on the disposition of assets held by Harlow Legacy Group, LLC, pending the outcome of the disclosure review, a requirement for an independent appraisal of all real property assets identified in Clara Voss's expert report, and a scheduling order for the validity challenge that set the contested hearing for 6 weeks out. Baines requested a delay on the independent appraisal on the grounds of operational disruption. Judge Osei denied it. Vivian sat at the petitioner's table beside Kwan with her hands folded in her lap and her face in the neutral. The attentive register she had developed for client meetings and board dinners, and all the other rooms in her life that required a careful presentation of self. She looked at Marcus across the courtroom aisle. He was in the same position, hands folded, face neutral. He was wearing the navy suit he wore when he wanted to project reliability. She had helped him choose that suit at a department store on a Saturday afternoon 4 years ago, and she remembered the specific quality of light in the store and the way he'd asked her opinion and actually waited for it, attentively and with genuine interest, and she had thought then that this was a man who valued her. She had been looking at the suit. She should have been looking at what it was concealing. She turned her eyes back to Judge Osi and did not look at Marcus again. The 6 weeks before the contested hearing on the post-nuptial validity were the weeks in which the world began to move. Not dramatically. It never moved dramatically, not in the ways that mattered, not in the quiet backstage of legal proceedings where the real decisions were made in conference rooms and expert reports and discovery responses. But it moved. The independent appraiser filed his report in week 3. The Tribeca commercial development was valued at $63 million. The hotel portfolio at $71 million. The Long Island Sound waterfront parcels at $44 million. The total across the 3 primary assets that Marcus had declared at a combined $47 million on the post-nuptial agreement was now officially on record as $178 million. Clara filed an updated summary report in week 4, incorporating the appraiser's figures and tracing the full asset movement sequence with the new numbers embedded. She also included a section Vivian had requested, a reconstruction of Marcus's financial position as of the date the post-nuptial agreement was presented, including the estimated market value of the transferred assets at that specific time, which established that his undisclosed wealth at the moment of signing was not merely higher than declared, but was, in Clara's professional judgment, materially and intentionally misrepresented in a manner that deprived the signing party of the information necessary to make an informed decision. Kwan filed the summary with a motion for summary judgment on the validity question. He argued that the combination of absent independent counsel, duress, and fraudulent concealment was so thoroughly documented that no reasonable finder of fact could conclude the agreement was enforceable and that the court should find it void as a matter of law without requiring a full evidentiary hearing. Baines filed a 30-page opposition. Vivian read it on a Saturday morning at the hotel desk, not because Kwan had asked her to, but because she needed to understand the shape of the opposition, the specific arguments that Baines had chosen to emphasize, and those he had chosen to minimize or omit, because the omissions were often the more informative document. The opposition argued, at length, that the absence of independent counsel was a procedural deficiency that could be remedied by a finding that the petitioner had been sufficiently informed, that the economic duress claim was speculative and unsupported by contemporaneous documentation, and that the financial disclosure, while admittedly imperfect, had been substantially compliant with the parties' mutual understanding of the agreement's scope. It did not engage, with any specificity, the Clara Voss expert report. It mentioned the report in 2 sentences and characterized it as contested, without explaining in what respect it was contested or who was contesting it. Vivian made a note on the graph paper notebook. They have nothing for the forensic analysis. She was correct. When Kwan filed his reply brief, he dedicated 12 pages exclusively to the absence of any substantive response to Clara's findings, noting that the failure to contest an expert report through counter-evidence effectively conceded its conclusions, and that those conclusions, specifically the intentional misrepresentation of asset values, were dispositive of the validity question. She was in Kwan's conference room when the ruling came in. It was a Thursday afternoon, 6 weeks and 3 days after the preliminary conference, and the ruling arrived by electronic filing at 2:47 p.m. Kwon opened it on his computer, read it in silence for approximately 90 seconds, and then turned the screen to face her. The court found the postnuptial agreement unenforceable in its entirety. 3 grounds. First, the petitioner had not been independently represented, and the respondent's attorney had represented a materially adverse interest at the time of drafting, creating a per se conflict that precluded enforcement. Second, the evidence of economic duress, the threatened disruption of care facility funding, supported by the journal entries Vivienne had produced and corroborated by her therapist's contemporaneous notes, which Kwon had subpoenaed, was sufficient to vitiate consent. Third, the financial disclosure attached to the agreement was materially deficient, having omitted assets with a combined value of approximately $130 million that were marital in character. And this deficiency, in conjunction with the forensic evidence of intentional asset transfers, constituted fraud in the inducement, rendering the agreement void ab initio. Ab initio. From the beginning, as if it had never existed. Vivienne read the ruling twice. She set down the screen. "What comes next?" she said. "Full equitable distribution proceedings," Kwon said. "Now that the Postnup is void, we apply New York's equitable distribution framework to the entire marital estate, which means the court will divide all assets acquired during the marriage according to what is equitable under the circumstances, and the circumstances," he gestured toward the screen, "are now part of the record." The full equitable distribution proceedings opened on a Monday morning in late May, with Judge Osei presiding and with both parties represented, and approximately 12 years of cumulative legal experience on one side of the table versus, on the other side, Daniel Kwon and a forensic accountant who had just produced one of the most comprehensive asset reconstruction reports the New York Supreme Court Family Division had seen in a calendar year, according to Kwon, who was not given to hyperbole. The proceedings were not a trial. They were a negotiated settlement process with the court overseeing the fairness of the agreement, which meant that Baines would make proposals and Kwon would counter-propose, and Judge Osei would periodically intervene with the expression of a woman who had been in rooms like this too many times and had excellent instincts for when a number was reasonable and when it was not. The first proposal from Baines, $25 million, structured as a combination of cash and a long-term annuity. Kwon's counter, $88 million, all structured as the Tribeca development at appraised value plus cash compensation for the hotel portfolio and waterfront parcels, the care facility reimbursement, credit for the dissipated consulting fees and legal fees. The second proposal from Baines, $40 million, cash, paid over 4 years. Kwon's counter, unchanged. He did not negotiate below his initial number. He had explained this to her in their first meeting. In a case with strong facts, you do not negotiate against yourself. You let the other side come to you because they have more to lose from a public record than you do. The third session was when Marcus arrived without Jeffrey Baines. He came in with a second attorney she hadn't seen before, younger, in a sharper suit, someone who had the energy of a person brought in specifically for this moment. Well, Kwon had anticipated this. The introduction of a fresh negotiator sometimes signaled a genuine intent to settle, because fresh negotiators didn't carry the emotional investment of the original counsel and could be more functionally direct. Marcus sat across the conference table. He looked at her. She looked at him. For a moment, the room had the quality of a photograph. Everything absolutely still, the afternoon light through the window cutting at an angle that hit the surface of the table and made a bright bar across the wood, and the two of them on either side of it like opposing points in a geometry that had been building toward this configuration for 6 years. He said, "I want to speak to her directly." The new attorney put a hand on his arm. Kwon looked at Vivienne. She shook her head slightly. My client's position is on the table," Kwon said. "We're here to discuss numbers." Marcus looked at her for another moment. There was something in his face she didn't have a category for and didn't want to build one. She looked at the bar of light on the table. The new attorney cleared his throat. "My client is prepared to discuss a structure that addresses the primary concerns raised in the proceedings," he said. He proposes the Tribeca development at appraised value to be transferred to Ms. Chen within 90 days. Cash compensation of $14 million representing her equitable share of the hotel portfolio and waterfront properties. a lump sum of $2 million for the care facility reimbursement, and a waiver of the consulting fee dissipation claim in exchange for a full and final release. The numbers were $63 million for Tribeca, $14 million cash, $2 million care facility, total $79 million. Quan looked at his legal pad. He looked at Vivian. She looked at the bar of light on the table. She thought about the woman who had stood at those penthouse windows in the middle of the night and felt like she had arrived somewhere. She thought about the drawer, now empty. "Legal fees," she said. Quan looked at the new attorney. "My client will consider the proposal with the addition of full legal fee coverage and an acknowledgement in the settlement terms that the post-nuptial agreement was entered under conditions that were not fair and transparent." The new attorney conferred quietly with Marcus. Marcus said, without looking at her, "Fine." The settlement was executed 11 days later. The Tribeca Commercial Development, a 12-story glass building in Lower Manhattan with a ground-floor tenant roster that included a boutique hotel chain and 3 restaurant spaces, was transferred to Vivian Chen within the agreed timeline, as was the cash compensation for the hotel and waterfront assets, the care facility reimbursement, and coverage of all legal costs. Vivian was in Connecticut when the transfer confirmations came through. She was in the sunroom at her mother's facility, and her phone buzzed on the arm of the chair, and she picked it up and read the notification from Quan, which said in full, "Everything is confirmed. Call me when you're ready." She set the phone face down. Her mother's hands moved in the small, careful language of her disease, and Vivian held them. And outside the sunroom windows, the Connecticut afternoon was doing what May afternoons in Connecticut do, which is to be extremely green and completely indifferent to the private dramas of its visitors. She sat there for a while. When she left, she drove back to the city on the Merit, and she thought about the Tribeca building and what she intended to do with it. She had already had 3 preliminary conversations with a commercial real estate management firm, and she had preliminary plans for the ground floor spaces, and she had a meeting with a bank about a restructured financing arrangement that would free up capital for the kind of strategic acquisition that a woman with $63 million of real estate and $14 million in cash could, only if she was careful and precise, and paid attention to the things that other people missed, build into something considerably larger. She was precise, she was careful. She had spent 6 years being paid nothing for those qualities, and she intended to now be paid everything. She pulled off the Merit at the New York state line, and she stopped at the first gas station she saw for a cup of coffee. It was the cheap kind, sitting in a pot, slightly iridescent at the surface. She took it without cream or sugar, because this was not a moment that required sweetening. She stood by the car in the flat May light, holding the cup. Her phone rang. It was a number she didn't recognize, and she almost didn't answer it. But something in her compliance officer's instinct, the reflex that said, "Always know what information is coming before you decide to decline it," made her pick up. "Ms. Chen." A woman's voice, professional, slightly tentative. "This is Diane Moreno from the Wall Street Journal. We're running a piece on the Harlow case. It's a matter of public record now, and we were hoping to have a comment from you." Vivian looked at the gas station. A delivery truck was idling by the air pump. A man in a reflective vest was eating a sandwich on the hood of a car. "I don't have a comment," she said. "We understand, but I wanted to make sure you knew the story is running." "What's the story?" A pause. "The post-nuptial agreement, the forensic audit, the Delaware trust structure." Another pause. "The consulting fee payments." Vivian drank the coffee. "Run it," she said, and hung up. She got back in the car and drove into the city, and the skyline came up ahead of her in the late afternoon light the way it always did, relentless and indifferent, and full of the particular kind of beauty that belongs to things that do not care whether you appreciate them. She thought about what it would have been. $2 million, the use of a car, a personal bank account kept deliberately thin, the provision in the post-nuptial agreement that Marcus had had Jeffrey Baines build for her, like a room with a low ceiling and a locked door and no windows. She thought about a man watching a woman's hand move across a signature line and feeling the satisfaction of a trap closing. She drove. The skyline did not move. She did. So in the weeks after the settlement, the world reorganized itself in the ways that worlds reorganize after the primary event. The journal piece ran on a Thursday morning, above the fold in the business section, under a headline that was accurate and unadorned in the way that the best journalism is. Harlow settlement reveals systematic asset concealment in post-nuptial dispute. The piece was 700 words, well-sourced from the court record, and it did not sensationalize anything because it did not need to. The facts were the sensationalism. Vivian read it over coffee at the small table in the hotel room, which she was still in for another 2 weeks before her transition to a new apartment. The kind of apartment she had chosen herself, in a building that was not the most expensive on the block. A house because she had learned the specific cost of living at the top of someone else's game. She read the piece without particular emotion. It was accurate. It reflected what had happened. It was entering the public record in the way that all things eventually enter the public record, and that was neither satisfying nor distressing. It simply was. What was more interesting, professionally, was the response she received over the following 2 weeks from 3 different people in her prior professional network. A former colleague from Meridian who ran an independent advisory practice. A woman she'd met at a conference 3 years ago who did asset protection work for high-net-worth clients going through contested divorces. And a call from a mid-size real estate investment firm that had read the journal piece and was interested in discussing a potential advisory relationship with someone who had, as their head of acquisitions put it in an email that she read twice with an expression she controlled carefully, a demonstrated understanding of complex asset structures. She responded to all 3. She took the meetings. She also met in the 3rd week after settlement with the management firm she had consulted about the Tribeca building, and she sat in their conference room, a conference room considerably nicer than Kwan's, with working lights and chairs that hadn't been rewebbed since 2009. Though she noted that none of the people around the table seemed as sharp as the people in Kwan's slightly flickering hallway, and she heard their proposal for managing the building, and she made 14 specific observations about the proposed management structure, 5 of which were immediately accepted, and 4 of which prompted a revision of the fee structure in her favor. The remaining 5 she tabled for the next meeting. She walked out of that meeting into an afternoon in early June, when the city was doing its aggressive summer preview, pressing heat down between the buildings with the relentless enthusiasm of a place that spends 6 months in cold and has no moderation in its seasonal transitions. She stood on the sidewalk for a moment, and she felt the heat on her face, and she thought about nothing in particular. Such which was its own kind of arriving. Not the arrival she had imagined at 29 or 30 or 31. Not the arrival she had been told a certain kind of life should feel like, but an arrival nonetheless. Her phone buzzed. A text from Kwan. IRS has opened a preliminary inquiry into the Harlow filings for 2018 to 2021. FYI. She put the phone in her bag. She started walking. She had 4 blocks to the parking garage and a meeting at 3 o'clock with the banker, and the Tribeca building needed a review of its existing tenant contracts before she could restructure the lease terms on the 2nd floor. And her mother's care facility had sent a proposed rate adjustment for the next calendar year that required her attention, and there was a reading list she had given herself: estate law, Delaware trust structures, with commercial real estate financing that she was working through in the evenings before she slept. There was a lot to do. She walked. The heat pressed down. Somewhere behind her, in a penthouse 29 floors up, a man she had once believed was a person of integrity was sitting with what he had been left with. Which was still a great deal. He had not been stripped to nothing, because that had never been the point, but was considerably less than he had planned for, and was arranged very differently than he had designed, and bore the specific kind of mark that comes from a strategy that was built on a false assumption about the person at the center of it. He had assumed she would be manageable. He had confused paying attention with gratitude. He had confused compliance with acceptance. So on, he had confused the woman who refilled the water glass and remembered the graduate programs and played her part with absolute precision with a woman who did not understand exactly what she was doing. She turned the corner. The parking garage was half a block ahead. Her phone buzzed again. A different number. She looked at the screen. Clara Voss. She answered. "I wanted to let you know," Clara said, "that I've been asked to serve as expert consultant for the IRS inquiry. I'll be recusing from any direct involvement with your case going forward, since there's a potential conflict of interest, but I wanted to make sure you knew, and also..." A brief pause. "I wanted to tell you that in 20 years of doing this work, your preparation was the cleanest I've ever seen from a non-professional. That first folder." Is the timeline. Vivienne was at the entrance to the garage. She stopped. "The journal entries helped," she said. The journal entries helped, Clara agreed. But the timeline, the sequence you built, that's what made everything else possible. There was a short silence. Clara, Vivian said, if you're ever looking to bring on someone who understands financial documentation and has a particular interest in complex asset structures, I was going to say the same thing to you, Clara said. My partner has been looking to expand our forensic practice. We're not ready yet, but in 6 months, maybe a year, would you want to have that conversation? Vivian walked into the shade of the parking garage. The temperature dropped. The light went from blazing afternoon to the cool gray-green of enclosed concrete. Yes, she said. She found her car on the second level. She got in. She set her bag on the passenger seat and started the engine, and the radio came on. A news station, the clipped cadence of a midday update, something about markets, something about legislation, something about the ordinary running of the world, and she turned it off. She drove out of the garage into the heat. She had a meeting at 3 o'clock and 4 blocks of legal reading before bed and a building with 12 floors in Lower Manhattan that now had her name on the deed, and she was moving through the city with the kind of forward momentum that does not require a name or a narrative arc or an acknowledgement of its own direction. She drove. On the corner of 5th and 43rd, waiting at a red light, she saw a woman in a burnt orange dress walking fast in the direction of Midtown. And copper hair, the kind of easy confidence that comes from never having been made to feel invisible, or from not having felt it yet. Vivian watched her for a moment. The light changed. She drove.